Hello and welcome everyone. I am Karnika Seth and I am a cyber law expert and I practice in the Supreme Court of India. Today we are here to discuss the I.P.C project module 8, which is cyber offences under the Indian Penal Code and challenges to the criminal justice system. Outset, we would like to emphasize here that we are talking about cyber crimes today. Cyber crimes, which are e-crimes, are more like the conventional offline crimes transformed into the digital world, which is online, and therefore they become e-crimes or the cyber crimes. The crimes which you used to see earlier, like theft or extortion or any kind of harassment, now those crimes are actually shifted into the online world. Reason being that it's very easy for a criminal to be we hide behind the anonymity which exists on the internet, and it's very difficult to track at times the IP address, which can be easily spoofed or concealed using software and other high-tech gadgets or softwares. Therefore, the criminals find it very lucrative to be online and deal in various kinds of illegal activities. Now, this is just an introduction on this module, but now we would be henceforth talking about the IT Act and the I.P.C and the various provisions which exist in the law that deal with cyber crimes in particular. Now, here we see there are different sections which apply in the cyber crime cases, along with the other sections of the IT Act or the sections of the I.P.C which may be invoked. Now, for example, when we talk about data theft, for instance, here section 66 is normally of the IT Act gets involved, but theft as such dealt with under the I.P.C is 378. Now, here we are talking about forgery, for instance, covered by section 463, criminal intimidation by 506. Now, under the IT Act, section 66A would deal with any kind of threats or any sending of or any kind of menacing or offensive information, or any kind of information which is false but sent in order to cause annoyance to somebody. Now, those are sections which could go in tandem with I.P.C. And when we talk about fabricating evidence, section 192, falsification of accounts, 477 of I.P.C, destruction of electronic evidence, section 204, waging war against government, section 121, hate speech covered by 153A. Now, various sections of the I.P.C would therefore be attracted in many kind of cybercrime cases depending on the circumstances involved in the case. Now, when we see criminal conspiracy, section 120A deals with it in the I.P.C, outraging the modesty of a woman in section 509 of the I.P.C. But if it were to be obscene content illegally recorded or unauthorizedly recorded, it would also fall under section 66E of the IT Act. Sale of obscene objects or books would fall under section 292 of the I.P.C. Cheating by personation covered by section 420 and 419 of the I.P.C. Similar sections exist under the IT Act also, like we have section 66C and D dealing with identity theft and cheating by personation. Receiving stolen property, section 410 of the I.P.C. Similar sections exist under section 66B of the IT Act. So, we have these two acts which go one hand in hand in various kind of cybercrime cases. Now, to begin with the first issue, let us talk about cyber stalking in the first place. Cyber stalking is basically to follow a person online. It could be to harass a person or embarrass a person. Now, that could be in various lead to various kinds of problems, because when a woman or anybody including a child is cyber stalked, that could be a major harassment and causing mental agony or other kind of suffering. That could be prevalent through social media or other channels by SMSs or emails. Now, that also maybe involves criminal intimidation, an extortion or a blackmail, and that this particular area of offence is dealt with under section 66 of the IT Act. And here we have various provisions which deal with this problem in the IPC also, and there is a punishment of up to 2 years and fine or both under section 506 of the IPC. Now section 66A prescribes the imprisonment up to 3 years and fine for cyber stalking. Now if you see section 503 of the IPC, anybody who is threatening another person so that he would cause injury to the person or his reputation or intimidate the other person, and that he would basically commit an offence of criminal intimidation. Now this is an offence which is punishable under section 506 of the this particular IPC, which has a punishment of imprisonment up to 2 years or fine or both. If a person is committing the criminal intimidation by anonymous mails, it could be by any fake email ID or an account, it could be through a fake profile created on a social media blog or a network. Now that would be punishable with imprisonment of up to 2 years in addition to punishment under 506 of the IPC. Forgery is governed by section 463 of the IPC. Now this prohibits this offence of forgery, any kind of tampering, creating of a false document or a record in order to cause damage or injury to public or any person would lead to forgery with a malintention, basically to defraud a person. And section 464 deals with the construction of the forged document by dishonestly or fraudulently making or signing a document basically. Now if someone is making or transmitting any false electronic record or affixing any digital signature or an electronic signature of a person, making a mark which shows that this is an authentic digital signature but it is not, and that is done with the intention to cause that this is a genuine document, or altering a document in such a way that it is actually not true, then this would again be covered by section 464 of the IPC. Now section 465 of the IPC prescribes the punishment of a term which could extend to about 2 years or fine or both. Now when we see the explanation to section 464, it says that the affixing electronic signature would have the same meaning as there is under the IT Act, section 2(1)(d) of the IT Act, which basically means adopting any method to sign an electronic record by means of electronic signature. Now I would like to say here that electronic signature as such, so far we have only been notified that the digital signatures are authentic means of signing under the IT Act. So far the central government has not given out any other notification which explains the other means of signing which are considered as genuine or authentic means of signing the electronic documents under the IT Act. Now if we see the forgery of electronic documents or records, there were cases of counterfeiting stamp papers, and also in the case of Parliament attack case, there were fake entry passes created using digital means. By using a laptop, a forgery was committed to create sort of fake entry passes. And there have been various other scams like the Abdul Karim Telgi scam we know of, and many data diddling cases where little pieces of information are altered or stolen which may even go unnoticed, but causes the basically the forgery of electronic documents, and that's something which is punishable by the. Now section 466 of the IPC deals with forgery of record of court or public registers. Punishment is for a term of about up to 7 years and also fine. The explanation to the section would state that the register includes any list, data or record or any entries which are kept in electronic form, and this is the same definition under the IT Act section 2. Section 467 deals with the forgery of valuable security. Now that's punishable with imprisonment for up to 10 years and liable for fine as well. Section 468 particularly deals with forgery for the purposes of cheating. Somebody is using forged documents in order to cheat someone, again punishable with imprisonment of up to 7 years and fine. And under section 469, forgery for the purposes of harming someone's reputation is punishable with imprisonment of up to 3 years and fine. Now when we look at section 470, a false document or an electronic record which is made completely or partially by forgery is known as a forged document. Section 471 explains that whoever uses this document as a forged document or electronic record as genuine, knowing that this is not so, it is punishable again as an offense. There are other ways of forgery and altering the accounts or records, like falsification of accounts. Now this is an offence which falls under section 477A of the Indian Penal Code and provides punishment for this falsification, including the electronic record accounts. Any clerk or officer or servant who deliberately, with the intention to defraud, that destroys, alters or falsifies any book, electronic record or a paper which belongs to his employer, and it makes or instigates making of this false entries or alterations or omits some data, that is again punishable with imprisonment for up to 7 years or fine or both. Now when we talk about fabricating evidence, let us look at section 192 here. Any person who is making a false entry in any book or a record or an electronic record, and he makes any document containing a false statement which he wants to use in evidence before a judicial proceeding, before a court proceeding, and before a public servant or before a court, say an arbitral tribunal, and the deciding authority who has to form an opinion based on this evidence which is brought in by the person. If he entertains an erroneous opinion touching any material, to the result of such proceeding is said to fabricate the evidence. So any false evidence which has been brought to the court, and the person who is to decide the case bases his opinion on that, is actually something which is punishable with the offence of fabricating of evidence. Now when we talk about destruction of electronic evidence, section 204 gets in place. Here the section basically deals with destruction of any document or electronic record which is called upon to produce as evidence in a court or in any legal proceeding, say before a public officer, or again with the intent that basically if he renders illegible the whole or any part of this document, he destroys it with the intention to prevent the same from being used in evidence, then this is basically punishable with imprisonment for a term which may extend to about 2 years or fine or both. Another issue which law enforcement often faces is the hate speech issue. What is hate speech in the first place? It is basically any speech which would cause to show any hatred or any enmity or animosity against any in particular, or as in a community or religious people of any particular religious faith. And this kind of hate speech is definitely an offence, because it invokes public sentiment and could even lead to situations which go out of hand, like riots, and disturbs the public order. And this is covered basically by the IT Act also under section 66A, and I.P.C also deals with hate speech, and there are few sections which deal with it, 153 also. Now if you look at the hate speech, if you look at this particular aspect, that section 66A is currently being challenged by a case which is pending before the Supreme Court of India, in order to get clarity on what is the meaning and import, basically it is challenge the constitutionality of the particular provision, and the main purpose is also here to see and clarify what is the embed and import of the various terms which are used by the particular clause, like offensive messages or menacing character. Now, what those really mean? So, there would be better clarity once the guidelines are laid down by the court in this respect. Now, if there is a particular message sent across which causes annoyance, intimidation, danger, inconvenience or obstruction, results in insult or injury or hatred or ill will, now those are crimes which will be constituting crimes under the IT Act as under hate speech. Now, the offences such as these, they may even involve cyber terrorism if they are to the extent that they would hamper or damage the national integrity or sovereignty or public order. Therefore, they are crimes which are very heinous. I mean, if you talk about section 66F, it is an offence which could even be punishable with a term of up to life imprisonment. Now, waging war against government is punishable again, as I said, and 153A of the I.P.C again deals with the similar offences. If there is any kind of public disturbances being brought about, it is a punishable offence of imprisonment up to 3 years or fine or both. Therefore, 121 of I.P.C, 153 or A of I.P.C, they all deal with such situations where there is public harmony which is disturbed because of hate speech, and such acts are again punishable offences. In case, I would like you to note that in case this offence is committed in a place of worship, it is punishable with imprisonment which could extend up to 5 years and also liable for fine. Now, in case of outraging the religious feelings of any class, if there is a caste or creed involved or particular religious feelings are hurt, then section 295A of the I.P.C makes the person liable for malicious acts and imposes punishment for a term of up to 3 years or fine or both. Now, section 505, it gives a punishment for making statements which amount to public mischief or creating any sort of enmity between classes or distinction which is unfair, and the offence, if it is committed in a place of worship also, that be covered. There in the normal cases up to 3 years of punishment is there, or fine or both, except 5 years in case it is committed in a place of worship. Then we talk about criminal conspiracy here. Criminal conspiracy is an offence under section 120A of the I.P.C. Now, based on what is the object behind that, imprisonment is imposed and provided from a minimum of 6 months to life imprisonment or both, and fine also is possible in this considering the circumstances of any case. Next we have here is section 509 of the I.P.C. Now, this is again a section which we see very often in cybercrime cases, particularly targeting women, where there is an act which is done either through email or fake website created, or a SMS or a particular objectionable email which is there circulated, something which captures her pictures illegally, which are obscene in nature. Section 509 is mainly in the I.P.C talks about insulting or outraging the modesty of a woman or intruding on her privacy, usually coupled with section 66E of the IT Act and perhaps even 67 or 67A in case of a video clip. This could be involved under the IT Act, and under I.P.C 509 is normally used in tandem with these sections of the IT Act, where any kind of such information is published or transmitted without the consent of the person, containing the images of the person which are obscene in nature. Now, this is imprisonment of up to 3 years and again fine of 2 lakhs or both, prescribed by the 66E of the IT Act. Now, defamation. This is another rampant problem we see under the current scenarios. I mean, a lot of times we see defamation, which used to be generally in the print media, is now also very rampant and found on the internet. Anyone can create any blog, any website, and try to put any information there against another person, which causes defamation. And without any substantial basis, if any false allegations are put on a person, it is a offence which is punishable by the law. Now, IT Act and again IPC sections are attracted. If we talk about section of the IPC, section 500 provides punishment of up to 2 years of imprisonment and fine, or both, for committing this offence. A person is actually guilty of defamation if he, either by words or even by spoken words orally or in writing, which are intended to be read, or by signs or by visible representation, he makes or publishes any imputation for against a person with the intention to cause him harm, knowing that this will actually cause harm to the person's reputation. There may be, there are in fact a lot of exceptions to the sections 499 of the IPC, and the explanations are mainly of this nature, that in case a person, there is a person who is reporting a public, like a judicial proceeding, this is not going to amount to a defamation. If it is a fact which is being reported, substantiated by some evidence on that front, again it would not amount to defamation. If it's something for the public good, that is again not defamation. So there are various exceptions to the particular offence of defamation also. And please note that defamation is also possible against a deceased person, and it could be not only against a particular person, but also against a company or an association or a group of persons. Now, under the IT Act, the offence of defamation is dealt with under section 66A of the IT Act, punishable with a term of imprisonment up to 3 years or fine, or both. In this case, there was a famous case of Nirmaljit Singh Nirula versus Yashwant Sinha. The plaintiff had filed a suit for injunction asking the restraint orders against baras4media.com, which was a website which is a news portal, but it ran a malicious targeted attack against the plaintiff to make undue profits. And the court granted a conditional injunction in this case and restrained the defendants from licensing, writing or publishing against the plaintiff on their website through any media which causes any defamation to the plaintiff. That was an interim order. In another case, the Vyakti Vikas Kendra versus Jitendra Bagga, the Delhi High Court has dealt with a similar issue, wherein a suit for injunction, again a restraint order was passed against the defendant, restraining the defendants from publishing defamatory materials about His Holiness Sri Sri Ravi Shankar, who is the owner of the Art of Living Foundation. And then there was a successful interim order granted in that case as well. Now, the next issue which emerges here is the pornography. Now, when we talk about cyber pornography, section 67 of the IT Act, along with 67A, which deals with sexually explicit content, section 67B, which prohibits child pornography, 66E, dealing with invasion of privacy, in the case of MMS clips, for instance, other main sections involved in this area. Section 292 of the I.P.C is also attracted, which deals with similar situations where a book, a pamphlet or a paper or a writing, a painting or any object which is deemed to be obscene, if it is obscene in nature, it is something which is punishable and is prohibited. Section 293 prohibits the selling of distribution or exhibition of any of such products or objects to any person under the age of 20, and these acts are punishable with imprisonment for a term up to 3 years and fine which extends to about 2000 rupees. Now, in Tamil Nadu versus Suhas Kati's case, the accused had actually posted obscene messages about a divorcee woman in a Yahoo message group, which led to filing of the complaint, and FIR was filed, and later on after prosecution, a sentence of 2 years of imprisonment was placed on conviction. In other cases, the Dr. Katari Sunil Kumar versus Hemalanali, here a criminal petition for quashing was filed by the accused under section 482. Again, questions of the use of 509 and 67 of the IT Act were involved, and the court rejected the criminal petition because the electronic evidence found was indicating that the accused had sent in fact the obscene messages to the complainant using his laptop. Now, that was tracked using the IP address tracking mode, and that was found that these messages did go from his system. Cheating by personation is yet another offence we very commonly deal in cybercrime cases. Section 66D of the IT Act punishes this act and makes it an offence punishable with imprisonment of up to 3 years and fine. Under the I.P.C, cheating by personation is an offence under section 419, and the punishment is for a term which extends to about 3 years, again fine or both. Data theft cases are also very common today, especially the corporates are very careful of what particular data they hold. They are making airtight contracts, they are making IT policies stronger, appointment letters have non-competes, and disclosure of like the confidentiality obligations are more adhered to, and non-disclosure of confidential information is more emphasized. Yet we still have many data theft cases, and particularly involving trade secrets of the company or any copyrighted materials like invoices, sales figures, or any confidential vendor lists. These are very commonly seen that they are being transferred by the employees to their competitors, or they join another competitor in business and leak the information of the ex-employer. Now, in those cases, section 66 of the IT Act does get involved, and not only that, the theft under I.P.C could also be invoked. And the only difference is here that in terms of movable property, 378 would apply of the I.P.C, but in case of intangible digital property data, section 66 covers the same. Now, we also see cheating as an offence is included in most of FIRs, because if the data has been stolen with the view to cheat the owner of the data, then misuse of the data happens, and cheating is normally a non-bailable offence, which we find in a lot of FIRs gets involved in and attracted in many data theft cases. Now, what exactly is cheating? Here the section of the I.P.C provides that the punishment is there for the cheating. It's up to about 3 years or fine or both, and there is a very clear saying that if a person is cheating and that is done with a dishonest intention, and the other person is maybe induced another person to deceive or to deliver any property which he owns, and to alter the same or destroy the whole or any part of the valuable security, that is punishable with imprisonment of up to 7 years and fine. Now, in many data theft cases which talk about the insider frauds, we see section 406 also gets roped in, because breach of trust is involved here, because it's an employer-employee relationship, and where breach of trust gets involved and a person is entrusted with a property and he is dishonestly misappropriating it, for example, that is again committing of breach of trust, and section 406 gives a punishment of up to 3 years of fine for that. Section 408 provides here that if a servant is committing the same or a clerk is committing breach of trust, the punishment is for a term of up to 7 years and also fine. In case of banking frauds, there's section 409 of I.P.C, which gets attracted with a term of punishment of 10 years and also fine. Now again, there are cases like Abhinav Gupta, for example, versus State of Haryana, where the employee was charged of stealing away in confidential information. He was charged under section 66 of the IT Act, read with section 420 and 406 of the I.P.C. Now, there was a prima facie evidence against him that he had taken away sensitive information and given it to a competitor after leaving his ex-employer. So, these kind of cases are now reported. Judgments are available for you to read and see what are the loopholes and how to plug those loopholes in making those contracts and vigilance tighter. When we talk about receiving of stolen property, section 66B of the IT Act deals with this particular offence, where a computer resource, any data, it could be also a hardware like a laptop or any communication device like a cell phone, which is taken away by someone, and that is punishable with imprisonment of up to 3 years or fine up to 1 lakh or both. Now, under the I.P.C, if we see, the receiving of stolen property is given under sections 410 of the I.P.C. Now, any property which is transferred by theft or extortion. Now, if it amounts to say criminal misappropriation or criminal breach of trust, which is stolen property, then the act is committed within or outside India, this particular section gets involved. Section 411 punishes this dishonestly receiving any stolen property with the imprisonment for a term of up to 3 years or fine or both. And section 414 punishes anybody who is assisting in the concealment of the stolen property with imprisonment up to 3 years or fine or both. Now, when we talk about the old criminal justice system, how it used to function, and now the cyber crimes which exist today, when we talk about a cognizability aspect in particular, here we find most of the crimes under the I.P.C as well as the IT Act are cognizable, and those particular offences where the punishment is up to 3 years, those crimes are bailable as well. Problem occurs because if the criminals are out on bail, they could tamper with any digital data or even destroy the same. That leads to a difficult enforcement issue, how to tackle the prosecution problem, considering the evidence is very, very important in these cases. Now, there is also a shortage of inspectors trained in forensic collection. How do you analyze the forensic data, how is it collected, how is it preserved, how is it presented in a court of law. We have section 65B of the Indian Evidence Act in particular, one needs to comply with in order to file or produce any digital or electronic evidence. Now, there are also delays in adjudication procedures which are causing a problem. The training, the lack of training in the law enforcement, the judges, or even the police officials who are actually collecting the data, the forensic examiners, dearth of forensic examiners. These are certain loopholes. They're causing delays in the enforcement of cyber crimes. And how do we tackle combating the cyber crimes, and how do we make the enforcement system better? That these are certain issues which are key areas to be worked on. Another challenge which is that anonymity on the internet exists, and we all know that these cyber crimes could be committed by any person from anywhere in the world. So the problems of international cooperation exist, how the data which have to be used in a case have to be transported from abroad, whether the particular country will cooperate. We don't have, India doesn't have a cybercrime convention which it is signatory to as on date also. So that's also an issue, and how we can seek international cooperation in this area is something we really need to work on. Now, there are important sections in the IT Act which allow compounding of offences. Section 77A, it basically stipulates that the court will not grant compounding in cases where the accused is liable under previous conviction. So, in those cases that is not possible, but otherwise there are possibilities of compounding of offences also, other than for the offence for which life imprisonment is imposed, or a term of up to exceeding the 3-year term has been given. Section 77 is there, which is a non-interference in provisions which grant compensation or confiscation or punishments. The section basically is in a case it is there where section 78 also is important, where power to investigate offences is there under the IT Act. Now, that is in a case where there is a grant of compensation, for example, that will not hinder the other punishments which may be granted under the Act. Power to investigate is also there under IT Act section 78, with inspectors and above rank, not the DSPs as used to be, and above rank. This has been changed now, and the power to take say inspect in a public place, those inspectors have power of search and seizure. Those are also very clear. And section 84B provides a punishment for abetment of offences. 84C provides punishment for attempt to commit an offence. So, even those are punishable offences. In short, if you look at the summarization of this module, many cyber crimes have specific provisions under IT Act which go in tandem with or are read with the I.P.C. in cybercrime cases. For instance, we have section 66A dealing with hate speech in the IT Act, and this similar section 500 in the I.P.C. Therefore, some of the sections would be taken from the I.P.C. in certain cybercrime cases, and when we look at the old criminal justice system and the present ones, we do have new challenges because there are delays in accepting the new digital world in terms of law enforcement, in terms of training, collection of electronic evidence, the training of the manpower to do that, and the tangible, the fact that this world, the internet world is so borderless. How do we get international cooperation and get evidence from abroad if we require in a particular case? The evidence can be easily destroyed because it is something which is digital and tangible, and it could also be that there is a difficulty in getting an extradition. Therefore, it is very important to know where the criminal is. How do we track the IP addresses? How do we circumvent, or how do we combat the problems of anonymity on the internet? Now, these are certain issues which are there, which are posing new challenges to the old criminal justice system. Thank you.